Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on exceptions for filing the appeals by the revenue in case of low tax effect. The issue before Delhi ITAT G bench in the present case was that if the assessee has not claimed any long-term capital gain as exempt, which is alleged to be bogus by the revenue, or the assessee has not claimed any short-term capital loss which is alleged to be as bogus by the revenue, whether the appeal is maintainable due to low tax effect as per the exception of the Central Board of Direct Taxes Circular number 9 of 2024. The issue has been decided by Delhi ITAT G bench in the case of Deputy Commissioner of Income Tax versus SATYA PRAKASH Gupta. This case is reported in 128 ITR Tribunal at page number 1 and the date of judgment is 24th September 2025. In the present case, the assessee filed return of income declaring business loss from trading in shares. When the case of the assessee was in scrutiny, the assessing officer was of the considered view that this is not a business loss from sale of shares or trading in shares, but this is a short-term capital loss, and accordingly the assessing officer made the addition on the basis of accommodation entries taken by the assessee in the form of short-term capital loss. When the matter was before the CIT appeal, the CIT appeal allowed the appeal of the assessee and said that in the present case, the case does not fall into taking of the accommodation entries, and the assessee has not taken any accommodation entries, and the assessee has not claimed any short-term capital loss, but the assessee has claimed the loss from the sale of shares as business loss. The tax effect in the present case was low, but the revenue filed the appeal before the tribunal by taking the shelter of the Central Board of Direct Taxes Circular number 9 of 2024 dated 17th September 2024. The assessee challenged the appeal by challenging that the circular does not apply to the assessee in the present case. It was the submission of the assessee that the circular gives the exception in the case of claiming the exemption by taking the long-term capital gain or the short-term capital loss. Since the assessee has neither claimed long-term capital gain or short-term capital loss, so the case of the assessee does not cover as per the exception of the Central Board of Direct Taxes circular. When the tribunal heard the matter, the tribunal was convinced with the assessee and said that in the present case, the facts were very clear from the income tax return of the assessee and from the order of the CIT appeal that in the present case, the assessee has not claimed any exemption under section 10 subsection 38 by claiming the gain as long-term capital gain, and neither the assessee has claimed short-term capital loss. So the case of the assessee does not cover in any limb of the exception given by the Central Board of Direct Taxes circular. Friends, this is a classic case where the revenue appetite for litigation comes to very clear. It has been seen that the revenue files the appeals whether the tax effect is low by taking the case of the assessee in any of the clauses which are covered under the circular, because if the circular will not be interpreted in the right perspective, so the basic purpose of avoiding the litigation will be defeated. So in the present case, the tribunal has given a very clear message that the appeals can be filed only in cases where the case of the assessee is very strictly covered as per the circular number 9 of 2024, and the clauses which are given therewith, that clauses should not be taken lightly. Those clauses cannot be stretched to other cases. If the case of the assessee falls very specifically in those clauses, only in that cases the appeal should be filed. So in the present case, the tribunal said that the case of the assessee is not covered either under the long-term capital gain or the short-term capital loss, but the case of the assessee is covered as a trading loss. So the case is not covered as per the exception given in the circular number 9 of 2024. At the end of this video, once again, I'm repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus PRAKASH Gupta, and this case is reported in 128 ITR Tribunal G bench, and the date of the judgment is 24th September 2025. Thank you, friends.